So our second keynote speaker is Ralf Sauer. Ralf Sauer is the Deputy Head of Unit in DG Justice and Consumers International Data Protection Unit at the European Commission, which covers data flows, both for commercial purposes and in the area of law enforcement cooperation. He has been one of the key negotiators of the EU-US Privacy Shield and has represented the Commission in the negotiations on a modernization of Council of Europe Convention 108. Currently, he is leading the discussions with a number of countries that have expressed an interest in an adequacy finding, in particular Japan and Korea. He regularly participates in international conferences and panels on data protection issues. Prior to joining DG Justice, Ralf Sauer worked for almost 10 years in the European Commission's legal service, among others representing the institution in the European courts. He holds an LLM and doctoral degree from Yale Law School.
I guess the original idea was to have a different order, to start with me and then go to Ronald, so you would have gotten the optimist view and then maybe the slightly more pessimist view, as I still believe it sounded like, and that would have probably more naturally led into the discussion. So I'm sorry about that because of my travel schedule. You now will go from pessimism to optimism, and then you have to somehow revert back to problem discussions. But I hope that's not a problem. I think, and that's why I'm happy to participate. This is a very timely conference. I think timely for a number of reasons. On the one hand, because of the scandals, the incidents that we have lately seen and that we're still grappling with. The latest one, of course, now with Google, but we're still quite busy in the European Union, both on the sides of the data protection authorities, but also in the Commission with the Facebook Cambridge Analytica scandal and the subsequent Facebook data breach. So that's something which I think shows us how important privacy protections are for individuals, but also, and that's sometimes forgotten at a more societal level, for democracy, for elections. You might have seen that we recently published a communication on how to protect elections against undue interference, and that of course has quite an important privacy element to it. So this goes beyond what we maybe originally thought that what data protection is about. It has an enormous importance, and so that's the negative side maybe, that we see the risks and challenges to that fundamental right. But at the same time, we also see quite some positive developments, and that's something I wanted to focus on a bit. We see developments at national level in a number of countries, and Ronald already referred to Brazil in one of the biggest Latin American country. And I happen to think that actually that law, as it has been passed, although it still misses some elements, and an important one, the independent authority, but the law as such is actually quite close to the EU data protection law, to the GDPR. So that's quite, we believe, an important development. We see that also Chile is preparing a data protection law. Mexico is already quite advanced, and we then also have quite some positive developments, I would say, in Asia. That certainly is true for Japan, where we are in adequacy talks. It's true for Korea, and Korea might even further develop its data protection law. As we have heard, there's also India, where we recently had an important judgment from the highest court, which recognized privacy as a fundamental right and data protection as a fundamental right, and which triggered a process of legislation which is underway, and we have seen a draft law there as well, which looks promising. There's also other countries in the region, ranging from Pakistan to Indonesia to Taiwan, where we see interesting developments. There's Africa, not to be forgotten, of course, where a number of countries are drafting laws, and some of them are already quite advanced, and we will focus on this in the coming years. And then even when one has to say even, I think even the United States, I think is finally waking up. I think knowing that it has fallen behind a bit, certainly at federal level, and so there's not just California. There's also some development, some movement now at federal level. Yesterday there was a hearing in the US Congress where the chair of the European Data Protection Board was a witness, among others, of course. But that shows that there is now a considerable interest also in the United States, and that would, of course, be very good news if we would finally also see legislation, if it is then effective on that side of the Atlantic. So a number of developments at national level, a number of developments at regional level. That certainly concerns the European Union with the GDPR. But we also have seen the Ibero-American standards developed by the network of data protection authorities in Latin America. That's also something to be looked at. It's very interesting and also quite strong, although it's soft law, but could develop into something more. The African Union has adopted a convention on cyber security and personal data protection. So a number of things also at regional level, and last but not least, and I wanted to come to this because of its relevance right now, and that's the Council of Europe Convention 108, so the Data Protection Convention, which was just opened for signature yesterday. You might have seen that, and already, I mean, this is a convention which is hosted by the Council of Europe, but it's open to every country around the world, and it already has, the current convention already has 53 state parties, and it has now been modernized, and this modernizing protocol has been signed yesterday by 21 of the participating parties, so that's a good start. Unfortunately, I should say this also, and I hope that will soon change. Turkey has not yet signed yesterday, but it's not alone. There are a number of other parties also not. So we hope that we will soon have all the signatures, and then it will move to ratification. Will of course still take some time, but that is, I think, the only multilateral instrument, data protection agreement, which is also modern and will, I think, have an impact in the countries that have signed it, and it will cover not just the commercial area, but actually also the entire public sphere, and I think that's also good news in today's world. So I think all of this shows that we grapple with common problems, common issues, common challenges around the world, and we are looking for common solutions. And I think that comes at a time when data, of course, moves increasingly across borders, and that's why it's so important, I think, to we believe to work towards convergence of data protection systems around the world. This gives legal certainty to business, but also, of course, to individuals. It will create trust and ultimately facilitate data flows with high protections. So that's a more optimistic view, I would say, of the developments that we right now see. GDPR, of course, I think it's undeniable, had an important impact on this development. It's often described as the gold standard for data protection, and it's amazing to see how much interest there is around the world in this law and explanations about this law, and so all of these I think conferences that grapple with these issues, I think are very important. But I think it shows that while one, of course, can criticize elements of this new law, that somewhere we have found the right balance, as I believe, and that should not come as a surprise, I think, because this was one of the most heavily debated piece of legislation in EU history, where all sides could weigh in and many compromises had to be found, which of course not everybody likes where the balance was struck, but I think there was a balance between data protection interests, but also a legitimate business interest and business needs. And that brings me a bit to the topic of today's conference. I think sometimes there is a criticism now that the GDPR is too much of a burden on companies, that it's creating trade barriers. That's a view which we certainly don't share. I think it's a misperception, sometimes maybe even a misrepresentation of some that don't want their country, for example, to go in the same direction. But I think that overlooks really the many benefits also that the GDPR has brought for business, for innovation. That goes from, of course, the harmonizing effect that the GDPR brings, the one-stop shop, the consistency mechanism, which makes it now much easier, I think, for business to operate on the European market. That relates to the simplification that the GDPR has brought. Almost all of the notification and authorization requirements have been scrapped that used to exist under the old directive. That applies, I think, to the risk-based approach. Very often the GDPR is portrayed as bringing now all these new obligations, but of course many of these obligations only apply for certain types of data processing, for more risky types of processing. And I think that is a fair balance. Where the risks are higher, the obligations and safeguards have to be more strict. But for other types of processing operations, business operators will not have to deal with things like having a DPO, for example, or carrying out a data protection impact assessment. And even data breach notification, of course, is something which doesn't apply, or this requirement doesn't apply in all cases. It depends on the risk that the breach poses. And one last example, maybe right to data portability, so the main new right that has been created. That's of course important for individuals, but it's actually also good for competition and therefore for business, because it allows individuals to switch and therefore for competitors to compete for the data of individuals. And I think that will ultimately be to the benefit of all. So there's a number of elements, I think, which one should also see. There are also elements which I think will reduce the costs that are sometimes claimed as the main drawback of the GDPR. Things like privacy by design will, I think, help companies to limit their costs if they, from the start, build in privacy protections. There's also a whole market developing. It's I think, amazing if today if one goes to conferences to see the offer of privacy technologies, software solutions, technological solutions. There's a whole market, and I think it will bring down the price for privacy protection. And that's, again, something which is good for business and balances the additional obligations that have been imposed. Last element, and I only want to touch this briefly, is the international dimension. GDPR is sometimes also compared to, or likened to a data localization law. A complete mischaracterization. Actually, all the transfer tools that we had in the past still exist, and they have been further expanded, made more flexible than before. And the Commission in last year, in January last year, in a communication laid out how it wants to use these tools, and in particular the tool of adequacy to facilitate data flows, in particular with important partners around the world. And we are pursuing this agenda right now, for example, with Japan and Korea. And with Japan, we are already quite advanced. We have already a draft decision, which is now going through the usual processes. And if we have this adequacy finding, this will because it will also be combined actually with an adequacy finding under the Japanese data protection law for data transfers from Japan to the EU. It will create the biggest area of safe data flows of the world, and this complements the free trade agreement that the EU has with Japan. So I think what I want to say is that convergence around the world is important, and it can pay off. It can pay off for countries and for businesses because it will make data transfers much easier and at the same time protect individuals, and that's what we need. So. As I said from the start, that's a more optimistic view, and I would leave it at that. And I'm happy to answer any questions if there are any. Thank you very much.
Ralf, thank you so much.
Yeah, it's a bit difficult to hear.
Your speech and also Ronald's speech, you helped us in terms of setting the stage for following discussions. But I'm very jealous about you just because you are in a sunny place. And in a few minutes, you will be free from the conference. But now we want to ask the audience if they might be, they want to ask some questions to you. I would like to invite Ronald again here to the stage, and Ralf is here. Now I want to ask the audience if you have any questions to Ronald or Ralf, please feel free to ask. It is a Q&A session. I encourage you, if you might wonder the details of the keynotes, the both speakers highlighted.
Here on the left.
Yes, yeah.
Our left.
Hi, thank you very much for both talks. It was very interesting. I have a question. I feel like you're talking about the benefits of the GDPR and stating that the harmonization effect is the biggest benefit. And I was wondering because, member states are still allowed to issue specific laws and they're doing so. So how does this a bit clash with the harmonization effect that the GDPR wanted to achieve? And is that bringing down that benefit to a certain extent?
Your question to Ralf or Ronald?
Ralf.
Ralf, okay.
I'm at least happy to answer to that. So it's true that the GDPR still in certain places allows for further specifications. So this, of course, this always has to happen within the framework of what is already there. It has to also respect the one, because if you look at the beginning of the GDPR, it has two main objectives. One is the objective of protecting fundamental rights to privacy. The other is, of course, the internal market objective. And so all the what is sometimes called flexibility clauses, although I don't like this term because, as I said, it's rather specifying certain elements. For example, the age of minors, consent for minors. I would call this more a specification, and all of this has to happen within that framework and cannot lead to an impediment to the internal market. And that's something which we, in discussions also with member states, are trying to ensure. So yes, there is a certain element still left of where member state laws can diverge. They're of course not supposed to have their own data protection laws in full anymore, because we're talking about a regulation. It's actually under EU law not even allowed to replicate these rules in domestic law. So those are limited specifications by member states on certain issues. And and so that's a certain limitation to the harmonization. It's correct, but of course you have to see where we're coming from. We're coming from a directive where we had 28 very, significantly different data protection laws, because of course let's say the harmonization effect of a directive is very different from a regulation. It's also no secret that we as Commission would have preferred to have even less of these specification clauses. We had to, the legislators have in their long negotiations decided on a few of them, but there's now a much greater harmonization than we had before. So maybe the perfect is always the enemy of the good. So it might not be all perfect, but it's a big step towards harmonization.
Thanks. So my question is also to Ralf, and I wanted to ask if, on the side of the Commission, are you taking any efforts to monitor how companies, especially companies outside of the EU, are actually respecting the GDPR's obligations? And the second question is, does the Commission see a space for, say, a regulatory innovation, like the model in which the policymakers engage with the companies? Because as Ralf said, as Ronald said, the rules of the GDPR in many ways are not new. The basic principles are the same, and there was almost no compliance before, and we can see very little compliance right now. So it might just be that it's not really that these bad companies just don't want to do it, or that the fines are not high enough, but maybe some other way to engage with them is necessary. And so the question is just, do we want nice laws all around the world, or do we want practice to actually live up to them?
Again, I'm happy to answer, just I don't want to, if Ronald, and I don't see Ronald, so I can also not even guess whether he wants to step in. If not, I would be happy to at least say something, and then maybe Ronald can add to that. On the monitoring, okay, I don't want to be evasive and say that the Commission is not the enforcer, but I should say it at least, because indeed we are not the ones that monitor actual compliance by companies. We are the policymaker. We were involved, of course, heavily in the drafting of the law. But this being said, I think that's not the main point. When it comes to foreign operators, of course, it's more difficult to check on them. So the tools that we have inside the EU, when it comes to audits, when it comes to sending questions in an enforceable way, it's more difficult, although foreign operators, to the extent they fall within the scope of application of the GDPR, have to, of course, appoint a representative. So there is an entry point for enforcement in the EU, but it's not, I think one shouldn't hide that it's going to be a bit more difficult than if you have an operator that is established in the EU. At the same time, we have now one important new instrument, I think, and that's the fines. Fines, of course, are not there to be imposed all the time. They're actually, the best fine is the one that's not imposed, but they are an important element of deterrence. And I think that's something, that's why there has been so much talk about the GDPR. As you said, there is actually a lot of continuity from the old rules, but the old rules indeed were probably often not complied with. And what has changed, I think, is the awareness that now there's a risk of not complying, and that comes, of course, from the fines. Even if they are in the end not imposed, I think that will change behavior, and the representative of a foreign operator under Article 27 of the GDPR can also be the one to which a fine can be addressed. So also foreign operators will not be able to escape if they would not even appoint or designate a representative. I think the data protection authorities will find other ways, and I think that might include warning about using operators that don't even comply with the basic requirement of having a representative in the EU. We will, of course, always have to rely a lot on complaints. We also have now some very active NGOs. As you know, under the GDPR, there's also a strengthening of private enforcement through privacy NGOs. And on the day of the entry into application of the GDPR, I'm sure you have all seen this. A first set of complaints was filed by a new NGO, which none of your business, that's the name of the NGO. And that concerned a number of foreign operators. And this has led now to investigations. So there is, I think, much more accountability now, much more awareness also of individuals. So we hope that they will also make use of their rights, including the right to bring complaints. And I think that's all we can do. So that's at least my part of the answer.
If I can add some brief remarks there. So in a moral community, people observe the rules not because they have to, because there are fines, but because they subscribe to the rules. Now that's maybe an ideal world. But if I talk to my students and I explain them the foundation of the GDPR on the basis of the principles that are outlined in Article 5, then it totally makes sense. I mean, you don't want to be treated behind your back. You want to have transparency. You want to be able to understand what a controller is going to do with your data. So that sounds very reasonable to me and plausible to me. On the other hand, indeed the principles were there already in the directive, as Ralf also said, and the fines may make a difference, although of course there's heated debate whether or not sanctions work in the first place, or whether you have to. So it's the sticks carrots thing. I'm a sticks guy myself, but there are plenty of carrot guys, carrot people as well. But one of the things that, and Ralf mentioned at the end, so there's a lot more of accountability in the GDPR. And actually, I think one of my hopes is that the data protection impact assessment will have a significant role. And the reason why I think that is important, because it's the impact assessment is a sort of self-regulatory thing. It is the controller that has to describe their operation, the risks that they see, the way they mitigate or want to mitigate those risks, and then the whole thing is documented. Now, the regulation is not entirely clear on how this procedurally works, and also not what the sanctions are of not doing this properly, etc. But in my hope, the impact assessments will make it to the public domain, ultimately, because of civil lawsuits against controllers, for instance, and then you have basically something that resembles a contract between the controller and the data subjects, where the controller has said, okay, this is what we're going to do, this is how we're going to treat your data, and if they then do not conform to the stuff that they mentioned in their impact assessment, then they have a problem in the civil domain. And that's sort of an enforcement mechanism that comes on top of what the data protection authorities can do in terms of fines. But that's a really long-term thing, because that will take endless amounts of litigation and what have you before this actually will be visible to the public. But we've seen similar things happen in other domains as well. So in the financial sector and other areas where we already had these sort of accountability provisions in a stronger form than what we had under the directive. With that, yeah.
Well, I think that's the end of the Q&A. I'm afraid we won't be able to take questions. Thank you so much, Ralf, and thank you so much, Ronald, for this amazing keynote session.
Sorry, we have another question here. So.
I'm afraid we cannot have more. Okay.
Oh, thank you very much. I'm sorry if I'm interrupting, so I'll be very quick. Alex Gakuru from Kenya. So thanks both for very insightful keynotes. It may sound like a joke, but where I come from, we actually have two different bills on data protection, one before the National Assembly and another one before the Senate. But let that not fool you that we are going to be double safer than other people when it comes to data privacy. So quickly, two quick questions. Either any of you can answer them, or one of you. What do you consider would be fair and reasonable critique of the GDPR, which can help us inform our ongoing discussions? That's number one. And number two, there is often the rule that you have the right to remain silent because anything you say can be used in a court of law against you. What safeguards are there to ensure that information collected through these platforms, because we have come to trust them, because we have been told our privacy and data is protected, cannot be used against us in subsequent legal proceedings? Thank you.
On the first, I mean, I can give it a try on your first point. I mean, what is a fair and reasonable critique of GDPR? I mean, I've tried to say that some of the more harsh critique, I think, against GDPR might be unfounded because people only see the costs, the burden, and overlook a bit the benefits that it actually brings, and also factors which mitigate costs. And I try to refer to things like privacy by design and so forth. I think one thing that if one wants to be critical, I think one can probably say it's a very long law. It's complex. Already the technique that we have in the EU with the articles and then recitals which stretch over, I don't know, I think almost 100 pages or something. It's of course something to get used to. So I think there is still a lot of, there's a need for explanations. But there again, I think our data protection authorities have a role to play, and they have made use of that role. If you have seen the stream of guidance papers that have come out to explain the things which are new, because you can already rely on a lot of guidance papers actually from the past, and many of these concepts are still the same. But to the extent there were new concepts, most of them have already been addressed through a guidance paper which went through public consultation, so also with input from the public, and which further give guidance and therefore legal certainty to all stakeholders involved. So yes, I see there a certain a challenge, I think, especially at the beginning when the law was adopted. It's much longer than the directive, despite of all the continuity. But I think there's more and more clarity, and of course companies also more and more get used to these new features. And for the rest, I think they will find out and have found out, and that's why I think the noise has considerably gone down. There's a lot of things which they actually knew from the past and which they can quite easily deal with. So I don't know, those are just some elements of how one can look at the GDPR. I think the fact that it's emulated in many places around the world shows that it is actually a good law that makes sense.
So I concur with Rolf here on the first part. So what I found amazing is, so I think there's too little guidance. I mean, there's a lot of Article 29 working party and the board guidance, etc. But that's not really helpful for the controller on the ground. So I remember that 2 months ago or something, I was approached by somebody who runs an association of tax lawyers across Europe. And they asked me the question, what do we need to do to be compliant as this are a little association for, in practical terms with the GDPR? And I thought, well, come on, I'm not the first one doing this, right? There must be some sort of guidance, and there was none. I mean, so what I noticed was that, interestingly enough, that the Boy and Girl Scouts across Europe, they had their thing in place. They had guidance for the scoutings on how to set up their simple administrations in a compliant way. But there's nothing for all these little sort of associations of people that don't have the capacity to hire legal people, that simply want to have let's say a checklist of these are the things that we need to do. And that I found fairly surprising. And maybe leave it at that, right? Yeah. Or the second, no, let me address the second question then a bit. Yeah, I mean, that's, and the other points of critique, I mean, I stand with the 3 strands that I said. So I think the GDPR is over-inclusive. I think that we should have taken the opportunity to be more strict about what we find acceptable data processing. And in my view, a couple of sort of uses should have been limited in the GDPR. And the third one is that that how to cope with with explainability, etc., should have been taken a little bit further. Regarding the second thing, I think that you point out at a really big problem. I think that we don't know what kind of data is being collected about us, and we don't know what the inferences are that are being drawn upon that. And yes, I would not be surprised that ultimately we might end up in court with information being presented about us through all these data collecting and tracking and what have you, that may harm us ultimately. And there's no way of stopping that, I think. Yeah.
Thank
But
you so
there are,
much.
of course, rules of due process, which I hope will kick in, and they apply to electronic data the same way as they apply to other pieces of evidence. So I think we're not in no man's land. I mean, there is a structure that we have for especially criminal procedural law, which will hopefully deal with some of these things. But it's true, I think, especially after well, in the world in which we live in, which unfortunately is also characterized by a number of grave threats, in particular terrorist threats, law enforcement has stepped up and it's expanding its tools. And indeed, there are problems, especially if this is coupled with a trove of data which companies collect. And I think we need to also address, of course, that issue that companies don't keep data, collect more data than they should, and keep them for longer than they should. So indeed, this will always, I mean, balancing privacy against security, for example, will be with us for quite some time. But I think it's solvable, and we have the instruments for it. And I wanted to congratulate Kenya for doing this work. We had read about the developments in Kenya, and I think that makes us quite happy that there is a debate on this, and we would also be very happy to engage on this, if I can use the opportunity.
And thank you so much for your amazing keynote speeches, and thank you for your